Okay, good morning, everyone. Good afternoon at this point. Um, I am Cristelia Garcia, and excited to welcome all of you. I know we've got a few students joining as well today, so thank you to those who've been able to join. It's my pleasure to introduce Professor Franita Tolson from the University of Southern California Gould School of Law to speak with us today about her forthcoming work on voting rights. She has a book coming out, and correct me, Franita, if I get the new title incorrect, but I believe the current working title is Rethinking the Constitutional Structure of Political Rights, the Evolution of Federal Voting Rights, Enforcement from the Founding until the Dawn of the Progressive Era, forthcoming from Cambridge University Press. She has published widely and extensively, as well as teaching in the areas of election law, constitutional law, legal history, and employment discrimination. And we could not be happier to have her here at a time when we are all probably quite anxious to talk about voting rights and election law and what that sort of thing is going to look like as we pull into November. Without further ado, I will turn it over to Professor Tolson to give us a bit of information about her upcoming book and her research in this area. And then, as we always do, we will open the floor to questions. I will be keeping the queue. If you have any questions as you go throughout the presentation, feel free to raise your digital blue hand and I'll keep a running queue on my side. And then when Professor Tolson wraps up, I will start going through the queue. So you can just raise your little hand and leave it up there. Thank you so much. I'll turn it over to you, Franita.
All right. Thank you so much. I am so happy to be here. I have been craving some sense of normalcy, and so it's really nice to be in a workshop. I'm working on a book project that initially started out as a labor of love, but now it's just kind of a labor. So I'm really looking forward to your feedback. So what I hope to do in this book is I want to clarify the scope of congressional power over voting in elections. And I think when I initially started this project, that has remained true throughout. But the focus of the project has changed and really evolved over the course of the last few years and trying to figure out the best way of presenting this information. But just in terms of the general thrust of the book, courts and commentators have assumed that states are supreme in the area of election regulation, in part on federalism grounds. But my book argues that this is a fundamental misunderstanding about the scope of congressional power. So part of the argument is that it's a misunderstanding because congressional power, contrary to most assertions, is that congressional power does not derive solely from the 14th and 15th Amendments, right? And those amendments have received outsized attention in this area. And in fact, we disproportionately focus on how the court has enforced and regulated congressional power under those provisions. But Congress's power to regulate voting and elections derives from both structural provisions that serve as express delegations of power to Congress, rather than the courts or the states. So these are the provisions that I refer to in the book as the Constitution of Political Structure. But congressional power also derives from the individual rights provision that tend to get the most attention. So those governing the right to vote, those provisions that empower Congress to enforce their terms through appropriate legislation. So I refer to that as the Constitution of Political Rights. So the book argues that through the Constitution of Political Structure, Congress has broad authority to regulate voting and elections, and this authority existed prior to the Civil War. But importantly, this authority was largely unconstrained by federalism, and it substantially increased with the ratifications of the Reconstruction Amendments after the Civil War. Excuse me one second. Yes? No, it's too early. Sorry, I have many children in the house. The Reconstruction Amendments in particular expanded the constitutional political structure, and it also altered the Constitution of Political Rights. So it shifted significant authority to protect the right to vote from the states to Congress. And in the process, it accorded the right to vote independent federal significance separate from its state law origins. So it not only changed the structural components that empowered Congress, but the individual rights components as well. So focusing on the evolution of congressional power also reveals a larger story about the creation of and really death of political norms. and more poignantly, the role of politics and partisanship in shaping the boundaries of federal power over elections. Congress had broad authority to regulate elections pursuant to the constitutional political structure prior to the Civil War, but of course, political norms dictated that it stay its hand. And honestly, it is these norms that was discussed in federalism terms as opposed to a reliance on federalism in and of itself. But as you see in the book, particularly the chapters that I circulated, these norms were quickly discarded when it became politically inconvenient to adhere to them. And this was true in the decades leading up to the Civil War. The book ultimately concludes that if we truly understood Congress's power in this area, we would recognize that not only is Congress supreme over the states in many more aspects of election regulation than Congress is given credit for, but it's also a co-equal branch with the Supreme Court in protecting the right to vote from undue encroachment by the states. The normative takeaway is ultimately that judicial review of federal voting rights legislation should be more deferential to Congress in light of the full spectrum of congressional authority over elections. And the court is able to do this once it takes into consideration both the constitutions of political rights and structure and how they have evolved throughout our history. So more in particular, the book focuses on 4 structural provisions that have not received significant attention. So the Guarantee Clause, Section 2 of the 14th Amendment, which allows Congress to reduce a state's delegation in the House if the state abridges the right to vote. The Elections Clause, which gives Congress a veto authority of sorts over regulations that govern federal elections. And also Article 1, Section 5, which gives Congress the power to judge the elections of its members. The book discusses how these provisions interacted with corresponding changes to the Constitution of Political Rights, both of which are integral to understanding the true scope of federal power over elections. So just to say a few words about the Guarantee Clause and the other provisions, and then I'll take your questions. So the Guarantee Clause guarantees to each state a Republican form of government. And it was widely viewed as setting a floor that the states could not fall below in determining what form of government to adopt. So no monarchy, no oligarchy, but a government ruled predominantly by majoritarian principles. The history, text, and structure of the Constitution, both as adopted in 1787 and as amended during the Reconstruction period following the Civil War, really reflected deep concerns about the concentration of political power in the hands of a few at the expense of the many. So state governments, in essence, tried to balance notions of Republican government with a desire for a narrow electorate, right? Voting was based on principles of deservedness. It was based on principles of independence. Who has proven that they are independent enough to exercise the right to vote? And so states did this by arguing that all citizens retain their natural right to alter or abolish their governments, even if they could not vote. So this was similar to the right of revolution exercised by the colonists against the British during the Revolutionary War. Like the right to vote, the right to alter or abolish government, although a natural right, would also become a political right that would eventually fall under the auspices of the Constitution of Political Rights, as it became subsumed by the right to vote. Congress, through the Guarantee Clause, became more aggressive about limiting the right to alter or abolish government in states readmitted after the Civil War, since the Confederates had used it as a justification to secede from the Union. But prior to the war, the existence of this fundamental right to alter or abolish government, which nominally belonged to everyone, and nominally is doing a lot of work in that sentence, it nominally belonged to everyone. It meant that you could have slavery, you can disenfranchise women, it meant that you can disenfranchise free Blacks and others who theoretically should have been able to vote, but still technically have a Republican form of government, which really illustrated the fluidity of these Republican principles. The book shows that the definition of republicanism, consistent with this sort of fluid notion of republicanism, the definition changed over time, and it shifted in a direction that gave the federal government a greater foothold in the regulation of federal elections. And part of this was to further ensure the Republican ideal of majoritarianism. So one example of a constitutional amendment that changed the definition of republicanism is actually the 12th Amendment, which requires that electors vote for the president and vice president on separate ballots. And it also provides that if no candidate garners a majority of the electoral votes, the top 3 vote getters, instead of the top 5, as was true under the original Constitution, will go to the House of Representatives. So it's long been considered a technical fix, but when you read the legislative history and understand the broader history behind the amendment, it's pretty clear that in altering the 1787 design, the framers of the 12th Amendment, both in what they changed about the original Electoral College and also in what they left the same, clarified that the majoritarianism centered on a majority of the voting population, right? So even in this technical fix, it is an alteration of Republican principles. The 12th Amendment preserved the ability of state legislatures to choose how to select their electors, consistent with the original Electoral College. But the Jeffersonian conception of majoritarianism, unlike Madison's vision, anticipated that the president would garner the support of those who held the political power of the state, either through the popularly elected state legislatures that chooses electors, or through electors directly selected by the voters. This is why the election of 1800 was so alarming, because it could have led to the election of someone, Aaron Burr, who did not have majority support among the public, even though I really loved him in Hamilton, I have to say, right? But it was no longer consistent with sort of this post-12th Amendment Republican ideal to have a president who only had minority support. Over 60 years later, Reconstruction would also change the definition of republicanism by altering the form that political rights had to take. Less alter and abolish, more voting, right? And the political community entitled to exercise these new political rights would expand during Reconstruction as well. By the Reconstruction era, the right to vote had largely replaced the alter or abolish authority as the mechanism through which people express their sovereign authority, right? It was no longer about this fundamental right to alter or abolish government, in part because as I mentioned, the South had used it to secede from the Union. Well, functionally, the elimination of the right, if it is truly a natural right, meant that it had to be replaced with something, and that something was the right to vote. In some ways, Reconstruction was the culmination of another shift in political norms, much like that which occurred during the antebellum era. Invocations of the right to alter or abolish government after the Revolutionary War were rarely respected when the politics made adhering to the norm in any consistent way politically impossible. Secession was the clearest manifestation of this breakdown in norms because it forced the country to confront why revolution had been okay using this right, but secession was not. So more voting, less abolishing the government after the Civil War. Reconstruction also affirmed that the Guarantee Clause and its focus on representative government remained an organizational principle that limited the ability of elected officials to disenfranchise those within the political community of we the voters, who are now the focus of republicanism post-12th Amendment. But now with the ratification of the 13th, 14th, and 15th Amendments, Congress embraced a different conception of who belonged in this community. And the Reconstruction Congress would rely on the Guarantee Clause to craft new political communities in the South in the wake of the Civil War, replacing the old communities that had been governed by the planter class with a much more egalitarian political order. This new class of voters, now governed by Republican ideals and entitled to voting rights, would include recently emancipated slaves, former slaves. And through Section 2 of the 14th Amendment, which penalized those states that abridged or denied the right to vote by reducing the size of their delegation in Congress, Congress could punish states that departed from this Republican ideal of majority rule. And many states did indeed seek to disenfranchise those within this new group of voters. So congressional Republicans, their explicit aim through Section 2 of the 14th Amendment was to bring African-American men into the political community of voters. However, Section 2 was never enforced, and its dormancy resulted not from the ineptitude of African Americans or their manipulation by Northern carpetbaggers, which is a narrative that was pretty typical at the time, but actually from fissures within the Republican Party, where Reconstruction policy became a product to be bartered or buried in order to achieve Republican political goals, dealing with economic policy, and also in response to the corruption scandals of the Grant administration. My book will show that Section 2 and the Guarantee Clause both still affect the scope of congressional power to protect the right to vote, despite the fact that they are ignored by the courts and commentators as potential sources of power. Similarly, the Elections Clause in Article 1, Section 5 also do not get their just due in narratives about congressional power. The Elections Clause empowers states to choose the time, place, and manner of elections, but importantly, reserves to Congress the power to veto state electoral schemes. Congress, by virtue of its authority to make or alter state regulations, determines the scope of state power, but with few exceptions, still must battle against political norms that implicitly favor state regulation. The Supreme Court has deferred to state sovereignty in this area because Congress's make or alter authority has been used sparingly. During the antebellum era, Congress rarely invoked the clause to nationalize federal elections or to limit state power to a particular substantive area. Instead, Congress assumed that well-functioning states would fill in most of the blanks with respect to the nuts and bolts of governing federal elections. Despite being rarely used, however, the Elections Clause has its own unique set of values that place a premium on congressional sovereignty. So when you have decisions like Shelby County, which basically ignores the Elections Clause and reads federal power very narrowly to protect state sovereignty, this is a mischaracterization of the historical and textual relationship between the states and the federal government over the matter of elections. Disputes over the scope of federal authority under the Elections Clause are memorialized in the historical record because of the House's authority under Article 1, Section 5 to judge the elections of its members. Historically, Congress's decisions to exercise its power under the Elections Clause and Article 1, Section 5 have been much more motivated and constrained by partisan considerations rather than any concerns about federalism. For example, the 1842 Reapportionment Act, enacted pursuant to the Elections Clause and requiring single-member districts, was considered blatantly partisan legislation that benefited the Whig Party. But the Democratic-led Congress decided to seat individuals who were elected in violation of federal law. So in violation of that 1842 Reapportionment Act, they seated them because they benefited politically from this decision. So it was partisanship and not federalism that motivated a lot of this legislation and responses to this legislation. Despite the controversy over the 1842 Reapportionment Act, very few scholars have probed the gold mine that contested congressional elections are with respect to clarifying the scope of federal power over elections, and in particular, how Congress perceived its own power. Nor has there been much discussion about how contested elections have also served as a vehicle to vindicate values preserved by constitutional provisions like the Elections Clause and the Guarantee Clause that focus a lot on federal authority. During Reconstruction, the Elections Clause and Article 1, Section 5 became formidable sources of federal authority that Congress used to not only advance its vision of a broader and more inclusive electorate, but also to police the boundaries of the political community of we the voters. Republican majorities in the House used their authority under Article 1, Section 5 to alter or to set aside elections that violated the 14th and 15th Amendments. Elections that exceeded the scope of the state's authority under the Elections Clause, or elections that violated other provisions of state and federal law. They were very aggressive about using this authority in a way that wasn't necessarily as extended in the antebellum era. In election disputes, the House did not require the state to necessarily hold another election when it determined that the winner of the election had been selected in error. Through its Committee on Elections, the House simply resolved the contest based on evidence presented by the two contestants. The House was not waylaid, Sorry, two 5-year-olds. So the House was not waylaid by concerns over the state's authority over elections, nor was it really concerned about the federal government acting in a domain that the states had substantial authority. Instead, Article 1, Section 5 really became a way to protect the formerly enslaved, while both promoting the ideals of the Reconstruction Amendments and also helping the Republican Party, right? Partisanship and politics are a very important part of the story. The Roberts Court nonetheless insists on interpreting congressional power over elections in a manner that misunderstands the original constitutional structure of elections, that minimizes the nation's march towards a more inclusive electorate, and also discounts the changes to the structure wrought by the Civil War amendments, right? We are not living under the Constitution of 1787. We're really living under the Constitution of 1868 and later 1965. Yet the court's perception that states retain sovereignty over elections that must be protected from federal overreaching really shows that it is a relic of a history that has been grossly misunderstood. So the book concludes by arguing that basically courts must incorporate these non-traditional sources for policing elections in assessing the constitutionality of federal legislation. Effective judicial review of modern voting rights legislation must account for the multiple sources of congressional power that govern voting in elections, as opposed to just focusing on one or two provisions at a time and assessing the scope of congressional authority. Once you think about congressional power as existing along a spectrum and involving multiple sources of authority, then Shelby County becomes more than just a cautionary tale about poor legal reasoning, right? It also highlights the important weaknesses in the court's methodology as a general matter, right? The case reflects the court's failure to interpret federal power in the aggregate based on all of the provisions from which such power derives. An approach that does so would properly account for the allocation of authority between Congress and the states in a way that more accurately reflects the Constitution that we're currently living under, as opposed to the Constitution that existed at the founding. Thank you.
Thank you very much, Franita. I will now take questions, and I'm happy to set up the queue. Feel free to just either begin talking if you want to be the first. Otherwise, if you'll raise your hand, I will call on you guys as we go through. And we'll start with Fred.
Professor Tolson, thank you so much for this. It's a terrific project, and it's so great to spend a little bit of time with you today. I'm a Fed courts professor, and I'm curious, by virtue of that, about your perspective on a couple of cases that touch on either directly or indirectly the guarantee clause, and in particular, the way that the court has construed the operation of the guarantee clause to be a political question. And so I'm curious about your perspective on, say, Luther v. Borden and Baker v. Carr, and how those cases fit or don't fit within the model that you're constructing, and the ways that you're either excited about or worried about the current Supreme Court leveraging those cases or manipulating those cases to keep the court out of a space where it seems like politically independent intervention might be especially useful.
That's a really great question. So I talk about Luther versus Borden quite a bit in the project because I think it's chapter 3, which I don't think I circulated to you guys, uses the Dorr Rebellion as an example of trying to understand the scope of the guarantee clause, and when the federal government in particular feels like its intervention is necessary. But an important and often overlooked aspect of the Dorr Rebellion is the fact that it was also the Dorrites in Rhode Island exercising their right to alter or abolish government in the face of a state government that they didn't feel was responsive to, anyone other than a white elite male individuals living in Rhode Island. And so I use it in order to contextualize the conflict between not only state and federal power, right? Because you had the established government, the General Assembly in Rhode Island asking for federal help to quell a rebellion. But then you also had the Dorrites who were exercising their right to alter or abolish government. And the founding fathers are telling us that this is still a right that people have, despite this new constitution. Yet you have political elites not being very responsive to invocations of this power, right? So the Supreme Court decision in Luther versus Borden, which basically said that they were not going to get involved in determining which trying to look for the word, which cohort, I guess, is the rightful governing body of Rhode Island, right? This is their way of saying we're not going to get involved in this. It's hard to look at that decision outside of its context, because the federal government had also declined to sort of weigh in. I looked at John Tyler's papers, and one of the things he says is like, look, I don't think that we should send help to Rhode Island because the violence had, the conflict had not devolved into true violence that warranted the federal government taking sides, right? But keep in mind, what it also was a conceptual conflict between established government and having a written constitution and people exercising their fundamental right to alter or abolish government. And President Tyler was very aware that by weighing in and choosing the rightful governing entity of Rhode Island, he is also implicitly saying something about the scope of the alter or abolish right, which political elites had long touted as this, this fail-safe. It is okay for us to disenfranchise women. It is okay for us to disenfranchise free Blacks who were in many ways, if they met the property requirements, were similarly situated as whites in terms of being eligible to vote, right? Because they've proven that they're independent. But it is okay to disenfranchise these people. It's not just about virtual representation, but it's also about this notion that if things get really, really bad, we are incentivized to do right generally because they can exercise their right to alter or abolish government nominally, right? Like this is something that they retain. And so in some ways, Luther versus Borden was a political decision to avoid weighing in on something which really set up this nice conflict between a fundamental right and, you know, I guess one might say this conception of whether or not people should be forced to resort to whatever mechanism is set up in their written constitution for resolving disputes, right? So you had this conflict between these two things. And so that was a really long wind up. So to get to your question, how might the Supreme Court use that? I'm not sure, because I think in the context of writing this book, I have a hard time of seeing it outside of its context, right? Because now we don't have a robust alter or abolish right. Now we are supposed to lean more on voting rights. And so in the absence of that context, I don't know how the Supreme Court would use that case other than as precedent to say, we don't want to be involved in this. But outside of that, I don't know if there's, you know, one could say there's this deep sort of theoretical commitment to, you know, the political branches defining what the guarantee clause means. I don't think the court views its role that way, right? I think the court just does it through the elections clause. Through the equal protection clause. Because this, in Baker versus Carr, this distinction between political questions and political cases is nonsense. It just is, right? It makes no sense. And part of it was, you know, Brennan trying to get around Luther versus Borden, but also recognizing that the court has a role in sort of defining the scope of our political institutions. I think that that's still true, right? But I think that the court has to do it in a way that is respectful of how the congressional power has evolved as well, which is why I make a point in the book of saying that the Congress is a co-equal branch. And the reason that is, I think, an important point to make is because if you look at cases like City of Bernese, the court is basically saying that Congress is not a co-equal branch and saying what the Constitution means, that congressional interpretation should be driven by whatever the court says that it means. One of the things I hope to achieve through my book is to say, like, no, Congress does have a role in articulating what the Constitution means with respect to political rights. They have exercised this authority throughout history, and it has manifested in ways beyond the full appreciation of what the court is doing now. So I think because of all of those things, it's really hard to say how the court would use Luther versus Borden, but I do think Baker versus Carr kind of illustrates that it's not really a barrier to anything, right? Because the distinction between cases and questions is nonsense. Sorry, no more 5-minute answers.
No, that's fine. Thank you. The next up, we have Ming.
Hi there. Thank you so much for sharing your book in progress. I have so much admiration for what you presented. I mean, I feel like it was really masterful as a history, but also just full of so much contemporary relevance. So
thank you so much for that.
Yeah, I really enjoyed reading it, and I'm saying that sincerely, not just, you know, because it's the right thing to say. So I think what I wanted to ask you about is this concept of republicanism that you put forward in the book. I know that there's a lot of the story that is about federalism and the balance of power as a matter of structure. And I do think that's really interesting and obviously really, really relevant to what's going on now. But the concept of republicanism to me seemed like such a theoretically rich part of the book. And so, and in particular, this idea of we the people versus we the voters, particular shift. And so I wonder if you could say a little bit more about the question of sort of explaining that, how that concept changes either in that moment or over time. You mentioned specifically, you know, the newly emancipated slaves. So that's a really obvious example of who would be needed, characterizing it one way or the other. But, you know, right now, and actually just yesterday, I was involved in this conference that the NYU Law School and Brennan Center put together. I think a lot of people you've worked with were virtually there too. But one thing we were talking about was the move from total population to CVAP, the citizen voter age population in the census and redistricting, you know, and then that would additionally leave out, you know, felons, young people, non-citizens, which is my focus in scholarship. So sorry, this is so long-winded. I think what I'm curious about is, in thinking about that shift other than a structural shift, what you would additionally say about the power relations, the race relations, or just demographic change behind that changing conception.
Okay, great question. So one thing that comes to mind is the expansion of suffrage among white men over the course of the 19th century, which is something you start to see almost immediately in the 1790s, right? It happens given, how much, it's like I can't win today. I can't win today. I'm sorry, excuse me, 1 second. All right, I'm so desperate. It's like 60 degrees outside, and I told my kid to go put on her bathing suit so she can go swim. Like, that's where I am at this point. So one thing that comes to mind is the explosion of like white male suffrage over the course of the 19th century. So I do think that was a response to the notion of republicanism and majoritarianism starting to better mirror the actual majority, right? So they weren't, let's be clear, it was still exclusive in the sense that they weren't trying to enfranchise women, even though women were enfranchised in some places over the course of the 19th century. It wasn't like a universal thing. And the same was true with some free blacks who could vote in certain states at various points, right? But generally speaking, I think that a lot of this is tied to the rise of mass political parties. And so I think that drove a lot of the changes in the definition of republicanism that you see with the 12th Amendment, right? The 12th Amendment became about who has the best political organization behind them that could organize for state elections. And then you elect a state legislature who will then give the electoral college vote to whoever the party's, nominee is, right? It became very much about partisanship and mass politics and political parties. And that also led to the explosion of suffrage among white men who were not necessarily a part of the political elite or part of the economic elite. And so republicanism did change in that way. And what you started to see is more of a overlap between we the people and we the voters. And once we get to Reconstruction, as you mentioned, those who were formerly enslaved, that overlap became even more. And then one would say with the adoption of the 19th Amendment, it further expanded. And then with the Voting Rights Act, it became more and more until there was less distinction between we the people and we the voters. But here's the problem. And if you have any thoughts on this, I have really struggled with the conceptual incoherence of these terms, right? The idea of a majoritarianism that is exclusive, right? They're excluding people. And part of it, and part of this project, and I'm trying to paint this vision of congressional power that's broad and that's designed to be more inclusive, but part of it was also premised on the notion of exclusion, right? So, in the parts of the book I haven't shared yet, I talk a lot about how one of the reasons why congressional power is perceived more narrow than it actually is because Congress wanted to give itself an out. Right. So Section 2 of the 14th Amendment, which allows Congress to penalize states, did not adopt a vision of directly forcing the states to enfranchise people. It's this sort of convoluted, incoherent way of trying to incentivize them to enfranchise people without having to bring the power of the federal government to bear on these states and make them do it. Right. Because they wanted to keep giving themselves this out. It becomes very difficult to talk about republicanism in a majoritarian way when Congress has basically set up a structure that allows states to continue to exclude, right? So in theory, I could say, well, even if Congress allows states to do this, they can reduce their representation under Section 2, they can punish them for it, right? So that is the incentive. But then they never used it. So is it really an incentive, right? And so, at the end of the day, I started to wonder if republicanism was just like this vacuous term that is driven by whatever the politics of the day are. And I think that's where I'm landing, right? And so when people say, this is not a democracy, it's a republic, to me, all I hear is, so we live in whatever system of government the politics of the day have determined that we live in. And frankly, that's a problem. But I do think the evolution of republicanism over the course of the 19th century sort of allowed Congress to act in a way that was substantially broader than Congress acted at the very outset of the century. But at the end of the day, we still have tough questions about a system that permits regression from that. And I think that's my concern. Yeah, I hope that's responsive. I think
I think it is responsive. I know there are other hands, so I don't want to say too much, but you did mention sort of wanting some thoughts on that. I mean, one idea, and this really comes out of the really smart people who were at this conference and know a lot more about this issue than me. But one thing we talked about was this idea of political membership, which I think has a lot to do with republicanism, even if it's not as anchored in a particular period of time. I wonder if either conceptually or historically, it might be useful to also consider other notions of republicanism, or this, the we the people versus we the voters, as it comes like in the census. Or the census is the one that occurs to me the most, because the conception of we the people versus we the voters has diverged more and more as over time, as there have been non-citizens who come into play. Like the new waves tend to be more demographically diverse, like more Asian and Latino. Again, the youth also bring their own ideological initiatives. So you start to see more of a splintering, I think, between we the people and we the voters than you might have had in that time period. And then similarly, birthright citizenship, that might be where I field from voting, but it might not be, because birthright citizenship is what would give you, it would enact the power to vote.
Yeah.
And this was something that I had discovered when I was researching this, that I just didn't really realize was a serious argument, but apparently it is. In both the birthright citizenship context and in the census context, there are sort of more restrictionist voices are claiming that immigrants, felons, others are necessarily outside of the political membership, not just on policy or political grounds, but because they actually believe historically and based on case law that they were not part of we the people, or in the birthright citizenship context, that specific phrase from the 14th Amendment, subject to the jurisdiction thereof.
Right.
They believed that they were not subject to the jurisdiction thereof if they were not in various forms of legal status or didn't have standing in terms of rights, or even Native Americans, are often used as the foil. Like if they don't have those rights, then these other disempowered groups are more like them, even though of course there's a pretty special relationship between.
I also noticed that with women who marry non-citizens, right, and they lose their voting rights, they lose their citizenship, and then they lose their voting rights.
Right.
It's right there. Can you pass my wallet, please?
I'll let the conversation go back to you and my other colleagues, but I just got
all right. Yeah, let's continue the conversation though. Thank you so much for that.
Thank you, Ning. Up next, we have Craig.
Okay, take that to your dad. Thank you.
Thanks so much, Franita, for this great set of chapters. So I have a comment just arising from the last exchange, and then I'll actually get to my questions. The comment is, I looked, so when I did my history degree in England, for some reason I decided to look at 16th and 17th century English intellectual history. And one of the things, and something that convinced me, so I was studying under someone who was looking at republicanism according to various political theorists, but what I got convinced of was very much this idea that republicanism, and I think you allude to this concept in your first chapter, republicanism was first understood to be in contradistinction to monarchy, and it was a point of intellectual convergence for different kinds of groups who believed that monarchy was bad, even if they couldn't quite agree on what they actually agreed on, So I think that vagueness has been characteristic of republicanism since its conceptual inception.
That's so interesting, because one of the things that I read and that confused me is the idea that republicanism can be consistent with the monarchy if you interpret republicanism as broad enough to encompass other forms of virtue and not just like political participation. And I'm like, what does that even mean?
Yeah, absolutely. And there were a range of other thinkers, but and we can talk about that offline, of course. The questions I had were, so number one, I was sort of so I was curious about your distinction between structural versus rights, structure versus rights, because it seems to me that there are many. It seems to me that the structure can be enforced in different ways, and to my mind, the structural protections, I've always, so I'll give you an example, right? So the 14th Amendment says, the Congress, that states will guarantee equal protection of the law, right? Whatever that means. And one of the arguments has been that that is also a structural protection in addition to simply providing individual rights. And to my mind, I guess when I think about structural, it means, policy enforcements that may or may not be, or policy structures that Congress may create that may or may not be enforceable through an individual cause of action. And then you can also create an individual cause of action, which to my mind, I've always collapsed the idea of causes of action and rights. And so to my mind, when you can create individual rights in order to guarantee certain structures of government, or you can guarantee certain structures of government through other means, such as Congress refusing to seat members that do not meet qualifications. Now that does not create an individual right, since no private individual can enforce that. Only Congress can enforce that. And so I guess to me the question would be, and I know that I'm not alone in thinking this. I know it's not the way the court sees this, but I do wonder what you might say to someone who says, look, yeah, the Constitution says that there are certain structural elements, that certain kinds of structure that have to be respected, but that structure can be enforced either through giving individuals a private cause of action and giving individuals right, and Congress can create those rights, or Congress may choose some other kind of mechanism. So it may say we are going to enforce it. It may say that attorneys general are going to enforce it, either state or, but that doesn't create a right. That would be more of a structural approach to enforcing it, or an administrative approach. So I guess I'm distinguishing between administrative ways to approach it versus private rights approaches to enforcing what is ultimately the constitutional structure. And the second question, if we have time, because I see one more hand up after me, is and so only if it turns out that there's time, is I'm sort of curious as to whether you think that you mentioned that Congress often stayed its hand, and do you think that enforcing certain constitutional structural ideals through rights, whether that creates a more uniform paradigm, because the idea is that anyone can come in and enforce it, whereas if you decide to delegate the power to administrative agencies or retain it within Congress itself, you might think only extraordinary situations result in enforcing it, only because at that point political tides will also be taken into account, which may not be taken into account when you're only talking about individual causes of action.
Okay, so my distinction between structure and rights is not really a focus on the right versus remedy question, right?
Yeah.
It's more so a reflection of trying to understand when Congress can act really independent of the court's interpretive authority, right? I do view the 14th and 15th Amendment as being heavily constrained by Supreme Court interpretation in a way that's not necessarily true of these other provisions. So to be fair, I don't know if I've thought about this extensively. So for example, the court has weighed in on Congress's power under the Elections Clause. So it's not that the court doesn't have anything to say about it, but because the court treats Congress as paramount under the Elections Clause, Congress doesn't have to worry about the court forcing it to do or not do certain things in the same way as it does under provisions that are explicitly constrained by federalism, right? And so for me, when I think about the right structured distinction and the fact that I'm saying these are provisions that delegate authority directly to Congress, I mean in a different way from Congress being able to interpret or enforce something through appropriate legislation, right? Because just by definition, they're constrained by the Supreme Court in a way that's not necessarily true of these other provisions. So it's less about, allowing other people to step in and also enforce these boundaries. Which is it's a conversation we've had in the context of federalism. Can an individual come in and enforce, our system of federalism? That's the Bond case, right? I imagine you can have a similar conversation here, but it really hasn't been my focus. I've been trying to think about this in terms of Congress acting largely unconstrained from judicial constraint. And that's really my focus on structure versus rights. Part of it, because the structure versus rights also captures the nature of the power, right? So when I say structural, it really is sort of about questions about the structure of state political systems, the structure of state and federal elections. It's less about a rights component. And I felt like it was important to disaggregate those two, because in the antebellum era, the states really were driving the right to vote, right? And so I didn't want to, give the reader a sense that Congress was using its power over the constitutional political rights to really step in and displace that authority. But they did make decisions during that period that affected the scope of the right to vote, right? That affected the way in which states regulated their elections. So I think in using those terms, I'm really trying to capture that dynamic and not so much the question of rights and remedies. With respect to your second question, though, it is entirely possible that if we thought about this in terms of remedies, it could create a more coherent paradigm. But I feel like we will still end up in a situation where a lot of that is entirely driven by the composition of the court. And one of the liberating things about this project is trying to get away from that. Trying to get away from a discussion of constitutional rights and the right to vote in elections that's completely driven by Supreme Court case law. And I think that's why a lot of this has been overlooked, because we are obsessed with the court. So I think that's my sort of thinking behind some of this, although your points are well taken.
Thank you, Greg. Up next, we have Jennifer.
Thanks, and thank you, Professor Tolson. This is truly fascinating, and so sort of full of ideas and philosophy and history and the sweep of everything, that I feel a little bad because I'm going to ask a selfish question and an anachronistic question, because my head is very much in like what's happening right around me right now.
Yes. Fair enough.
So the selfish question is that, among other things, in the election in a few weeks in Colorado, we're going to be voting on whether to join the National Popular Vote Compact. And some of what you have written and talked about has made me think about that and about the question of Congress's role in either consenting to or rejecting that compact. And the rhetoric around the compact has, always begins with, well, the first thing is state legislatures can do whatever they want,
right,
to choose their electors. And your comments were making me think, well, maybe not so much if Congress thought that that it's non-Republican or not fair or something to ignore the state's vote. Like basically your description of like basically the things that have changed didn't just change isolated pieces of the Constitution, they changed the whole warp and woof of it. And would this be something that is changed and that Congress should have a bigger role in? And then I was also sort of wondering, this is the anachronistic one, kind of if you would talk about like what's your legislative agenda for Congress under this conception of their power. You mentioned Shelby County, obviously, I think shoring up things they've already tried to legislate would be one of it, but do you have a wish list of what Congress should do with this conception of power that you're describing?
Okay, great. So let me start with the question about the National Popular Vote Initiative. That was hard for me because I do think it is more consistent with the post-12th Amendment Jeffersonian conception of majoritarianism, right? It's saying that we care about the people in the states and what they want, what a majority of the voters want. It seems entirely consistent with that. But there is a federalism dimension here that is hard for me because in the book I'm saying, well, federalism isn't driving a lot of this, right? But it is still driving some of it, right? And so when you have the national popular, so there's two things, and most of this comes down to the court though, right? It depends on if the court sort of elevates federalism as its primary concern to the exclusion of all else, right? Because to me, based on my book, there's a story you can tell about the National Popular Vote Initiative being consistent with our conception of republicanism post-12th Amendment. But the problem is that the court, because the court sort of elevates federalism to, as really trumping everything else, you can imagine the court saying, look, this is displacing the role of the state legislature in choosing the electors, right? The people in many cases are bypassing the state legislature. And there's this doctrine called an independent legislature doctrine, which is a reading of Article 2, which says that state legislatures cannot be constrained in how they allocate electors, even by state constitutions, right? So even if the state constitution comes in and says, like, look, we're going to change the state constitution, we're going to adhere to the National Popular Vote Initiative, or we're going to change state law more generally, when state legislatures are acting pursuant to Article 2, they cannot be constrained in that way. Now, that doctrine scares the hell out of me, I have to be honest, because think about what the state legislature is talking about in Pennsylvania, right? But it is a thing and it exists. And, if the Supreme Court adheres to something like that, it could use it to find that the National Popular Vote Initiative is unconstitutional. But let's be clear, to do that will require it to elevate federalism on top of everything else. Right. And so my hope is that the book shows that there were a host of other things going on that drove a lot of these categories. Right. Like, I'm not saying that federalism wasn't a thing that existed, but I hope that I'm also showing that it was a political construct that was disregarded when it became politically inconvenient. Right. Such that we shouldn't feel so comfortable today saying that things are a violation of our system of federalism. A lot of that is just whatever the political norms are, governed by the politics of the time. So for me, that one's hard because I don't think that if this ultimately gets to 270 and it comes before the court, that they'll look upon it favorably. Your second question, my legislative agenda, that's actually very fun. So I did get an opportunity to talk to the House Judiciary Committee about reauthorizing the Voting Rights Act. And so I was able to push this aggregate view of congressional power and sort of telling them that they can reauthorize it and not just rely on the 14th and 15th Amendments, but they can also consider the Elections Clause. So that was pretty cool because it gave me an opportunity to actually say, like, look, you can do these things and you just have to be explicit about it and build a record that the court can look at so that the court doesn't feel free to disregard the other constitutional provisions that bear on the constitutionality question. But what I think is really important is, and this has probably no chance of happening, amending the Constitution so that there's an explicit right to vote. It would moot a lot of the concerns that I have, a lot of the concerns that drive the book, right? Because if you look at the legal scholarship over the last 20 years, everyone acted like the Voting Rights Act was some super statute that was beyond constitutional invalidation, right? So a constitutional amendment would moot a lot of these concerns, and we wouldn't have to rely on, shifting majorities, and, we wouldn't have to have these fights over Supreme Court appointments, at least as it bears on this issue, if we just had an amendment that protected the right to vote in just a colorblind way that provides an affirmative right to vote, and that actually requires strict scrutiny. So a bill has been introduced in Congress to do exactly that. So I was happy to help draft that, but it's probably going nowhere. So I'm just here.
Thanks. That sounds like a good agenda.
Thank you, Jennifer. Well, in our 1 minute that we have left here, I wondered if I could jump in and ask a quick question. As Jennifer alluded to, my mind is also very much focused on right now the upcoming election in November, and I'm curious, as all of us are following this and keeping fingers and toes crossed, what you see as sort of the most interesting aspects of what we're about to encounter, given the messaging around, vote by mail, the messaging around, moving away from an electoral college. Like, what do you think are some of the most, for you as someone who writes and researches in this area, what do you see as the most interesting issues raised by the upcoming election that we should be focusing on?
So, I think it's important, and one thing I've just been very clear about with people both in the academy and outside of the academy, my family, have a plan for election day. Colorado is easy. You guys just do everything by mail, right? But everywhere else, people have options about how they'll turn out. So I've been telling people have a plan, and I think part of it, though, to understand why it's more than my commitment as like a voting rights warrior. I think one of the lessons I've learned in the last 4 years is how much our institutions have failed us. And so that made me even more cognizant of the fact that it's really important to have a clear conception of what the right to vote requires. Like when we say that people have a right to vote, what does that mean? Because our conversation over the last 2 centuries has been about what states can't do, as opposed to what the right to vote actually requires states to do, right? We know that states cannot discriminate on the basis of race when it comes to extending the right to vote. But we don't have a conversation about what it means for someone who has a right to vote. What does it mean for them to be able to exercise that right? Right? Does the state have an obligation to provide enough precincts and polling places? Right? Does the state have an obligation to, if they're going to have a voter ID requirement, to have a reasonable impediment provision where if people can't get the underlying documents to get the free ID because the underlying documents cost $1 million, are they required to do that in order for people to be able to exercise their right to vote? Because in my view, part of this is part of our problem is that we find ourselves in a situation where we don't have an affirmative vision of what voting rights means. And instead we talk about the right to vote in terms of what the state is prohibited from doing. And honestly, a lot of that ship has sailed. We know that states cannot discriminate on the basis of race, but because we don't have an affirmative vision of what voting requires, a lot of things pass, even though they have a disparate impact on people of color, right? Because we are not clear in articulating what the scope of the right to vote actually is. And so I think, once we get past this election, for those people who litigate these cases and people in Congress, it will become really important to articulate a vision of voting that prevents a lot of the voter suppression that is currently happening. And I don't necessarily think we have to amend the Constitution to do that, but constitutional amendment is a way to cement and guarantee any changes that we're able to enact. Otherwise, it's just subject to shifting congressional majorities, right? And we've learned a lesson about that the hard way. And so I do think, part of my urgency in saying vote, 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 and have a plan is because I realize that there has to be a change in order to cement the needed changes to the right to vote in order to protect it going into the next round of elections. So that's where I am. Terrified, but hopeful.
I think that describes my current position as well. Thank you so much again for your time today. And I everyone's muted, but I think I speak on behalf of all of the faculty and the handful of students that were able to join us today in saying thank you very much. We appreciate
thank you so much
your
for
time,
having
and
me.
thank you for sharing this amazing project with us.
Great questions, and sorry for my children who have no respect. But I imagine many of us are going through the same thing. So I
was going to say, thank you for making my kid look normal. Thank you.
All right. Take care, guys.
Bye, guys.
Bye.